To be heard today is 24-1163, Dierickx versus DreamDirt Farm and Ranch and Vale Holdings. Appearing on behalf of the appellant is attorney Nicholas Huffmon, and on behalf of Vale Holdings is attorney Alexander Barnett, and on behalf of DreamDirt Farms is Joseph Borg. So, counsel, when you're ready.
Thank you, Your Honor. May it please the court. I'm Nicholas Huffmon on behalf of plaintiff appellant Stephen Dierickx. The heart of this case, I believe, is contract formation 101, offer and acceptance. Consideration appears not to be disputed. Now, my client, Stephen Dierickx, participated in an online auction for certain farm real estate. At the close of the auction, he was the high bidder on real estate identified as Tract 3. Within minutes after the auction closed, he received an email from the email account of one of the DreamDirt auctioneers. It read, the body of it read, "Congratulations on your auction purchase." It said that he had quote unquote won the item, meaning Tract 3. It also contained an invoice and a balance due for the amount that he had bid. Now, this email came from the personal work email account of one of the auctioneers and named defendants, Jason Smith. It did not come from anything that would have identified it as an automated email, such as no reply at, etc. The email in question bore the logo and address of the company. I believe that offer and acceptance were clearly established in that moment and that a final and binding contract was formed.
Just to be clear, what do you think was the offer and what do you think was the acceptance?
The bid at the auction was the offer. I think that is very well established in the law, and we've produced expert reports from auction experts. And then the acceptance is the purchase email. The use of the words, "Congratulations on your purchase," identifying him as the winner, providing an invoice. All this was communicated by DreamDirt, the authorized agent of the owner of the property in question, Mr. Gatsionis.
I mean, you've pointed out some of the favorable facts in that email, but I mean, what do you do with the other terms and conditions, that were both in that email and on the website, like saying the sellers reserve the right to take up to 4 hours after bidding to accept the final bid, and saying that being the high bidder does not form a contract until it's announced as sold and you are notified that the seller has accepted your bid?
Yes, Your Honor. I think first we need to establish the standard that means of assent and contract formation are established by an objective, reasonable person standard, asking what a normal person would understand certain words to mean in context. So you need to understand the context of the email, that the body of it, as I've said, is very clearly an acceptance. And then you have a dividing line in the email, and everything below that dividing line is really just a copy and paste regurgitation of terms and conditions that existed prior to the auction.
Is there anywhere in that email where it says, the landowner, the seller has accepted your bid?
I don't think it uses the magic words like accepted, kind of like that. But when you have the words purchaser, won as in winning, and an invoice, I think there just really is no other way of understanding the word purchase other than a final agreement that has been made.
Contracts 101, because when I was reading your briefing, I could hear my law school professor's voice in my head saying meeting of the minds. When do you think that occurred based on this bid and responsive email?
The meeting of the minds was completed upon the sending of the email. That is the acceptance. And as I've cited in the brief, there is a rule in the restatement. It's sometimes called the mailbox rule. I didn't use that phrase, but it is restatement. Section 63 is the one that says that when a person making an acceptance, the written document leaves their hand, it is binding as of that very moment. and that no rescission or withdrawal is appropriate. And to your point, you use the phrase meeting of the minds, which of course exists in the law, but I think it's somewhat misleading because mind implies subjective. But the case law says that the meeting of the minds is in fact objective.
So you think that occurred when they hit send on that acceptance of the bid?
Yes, although apparently defendants claim that Mr. Smith didn't actually hit send, but what they did is they chose to use this supposedly automated system. Like he knew it was going to happen, so when that system sent it on his behalf with his approval and authorization, that is when the contract became final.
What's your strongest authority that that acceptance could be binding on the landowner at all when the terms and conditions say the landowner is going to have 4 hours? I think the evidence is undisputed that, there was no actual acceptance by the landowner. You have to be latching onto this email from the auctioneer when they had a contract saying that, they didn't have authority to do that.
The contract says up to 4 hours, so I just want to point out that the first response, I think, is the effective one, and then they waived any time after that. That's the meaning of up to. As to, I think, your larger point about how can the principal be bound, this is not in the brief, but I'll read you a quote from a Supreme Court case. Quote, as pointed out by Cargill, one of the parties, an agent can still enter into a contract on behalf of a principal. When an agent acts within the scope of authority on behalf of a principal, a contract arises with the principal. That's Winger Contracting Company versus Cargill Incorporated, 926 Northwest 2nd, 526, Iowa Supreme Court, 2019.
What's your argument? How would you say that the auctioneer was acting within the scope of the authority when the contract between the auctioneer and the landowner said that the landowner had the right to accept?
Let's talk about how agency relationships are formed. There's 3 ways. There's actual, there's implied authority, and then there's apparent authority. I think there's strong arguments for all of them. That the listing agreement that you just referred to as giving Gatsionis the right to accept within, or will only be sold with his consent, that document also says that DreamDirt has the exclusive right to sell, which I believe is actual authority to accept on Gatsionis' behalf. Now, if DreamDirt violated a later provision in that by accepting a bid without authorization by Gatsionis, the remedy for that is for Gatsionis to seek a remedy from DreamDirt. That does not involve my client. It does not affect my client's property rights. Now, that's just actual authority, and I think there's good arguments for implied authority, but what I really want to jump to is apparent authority, which is when the principal sort of communicates to the general public that an agent has their authorization. Now, Gatsionis held DreamDirt out to the public as his agent for literally everything in this auction. DreamDirt was responsible for advertising the auction, conducting the auction. DreamDirt was responsible for communicating with bidders or potential bidders before and after the auction. It was ultimately going to be DreamDirt's duty to, in fact, make the acceptance. So they clearly had the authority to make that kind of acceptance.
Refresh the facts a bit. Did your client pay the 10% down upon acceptance?
No, it's very clearly stated in our answers to interrogatories and also further developed in the affidavits that after the auction, the DreamDirt auctioneers called him and said that you're not the purchaser, that, well, my client responded, like, we have a formal contract, I'm going to enforce it. And the answer to interrogatories specifically says that Stephen said, where do I send the earnest money? And DreamDirt said, you're not the purchaser, we will not accept it. even if you send it to us, I think is it's the obvious implication. So that does excuse any lack of performance on his part. Now, I do want to point out that the defendants have never even attempted to provide an alternative explanation of the word purchase other than a final and binding acceptance. Similar to the word one, they have not offered that. In fact, the briefing for both parties, I believe DreamDirt does not, run out of time, but with permission. The response brief for DreamDirt does not quote the purchase email, the body of it, even a single time. The response brief for Vail Holdings quotes the email exactly once in the last paragraph before the conclusion.
Thank you. You have additional 5 minutes on rebuttal. It's my understanding the attorneys are going to be splitting time, so we'll have you keep track of that yourself. So counsel, when you're ready.
May it please the court, counsel. And my name is Joseph Borg. I'm an attorney from the Dickinson Bradshaw Law Firm. I represent what I refer as the DreamDirt defendants, DreamDirt Farm and Ranch Real Estate, Tom Bradley and Jason Smith. Plan is to speak for approximately 6 minutes and then give counsel time. So any questions you have for Vail Holdings, he can have time to answer those as well. But we believe the district court's decision is sound in this case, clear non-acceptance in this. I'll point out my DreamDirt defendants are, just for some of the claims, are licensed real estate brokerage and licensed real estate professionals in the state of Iowa. That just relates to the 714H claim for that purpose. But we believe the facts are clear. This was ripe for summary judgment. The facts are undisputed in this matter, and we believe the law is as well. The real estate contract entered into between the DreamDirt defendants and Mr. Gatsianis on April 12, 2022, make it clear that the property would only sell subject to Mr. Gatsianis' confirmation. He had the right but not the obligation to sell to the high bidder. And we believe there, which the court has asked some questions, counsel has dealt with the authority that would be in place for DreamDirt in this case. We believe that is very important, that they have no authority to sell the property without that confirmation. Then that was explained to all bidders prior to being able to bid. And I think that's important. The district court noted this as well. So this isn't a passive, the bidders were online bidders. The plaintiff was an online bidder. Before you can make a bid, you have to make an affirmative acknowledgement of the terms and conditions. It's not a passive that the terms and conditions are just on the website in case you happen to, look at them. You have to affirmatively acknowledge the terms and conditions.
Is there a factual dispute on that issue, though? I mean, I think I saw an affidavit in the record saying that he doesn't recall clicking on that and didn't think he did.
From our perspective, there is no dispute because that's the only way. We have an affidavit from the auction method, the software developer, that says that is the only way that you can proceed to bid, is if you affirmatively acknowledge the terms and conditions. And that's from from Mr. Smith as well, the broker, in his affidavit as well, that there is no possible way to make a bid without those terms and conditions.
Matters? I mean, if the terms and conditions are posted on the website and they were sent in the email, does it matter? If we thought there was a fact dispute, does that?
So I think it just helps making an affirmative that the bidders are acknowledging it, and we believe it would still be the same if it was still on the website or, announced the day of the auction. But here it's an online, so on the website. We don't believe that. But what is important is in there, the seller reserves the right to accept or reject any and all bids. Seller reserves the right to take up to 4 hours after bidding ends to decide. And being the high bidder does not form a contract until the auctioneer announced the property sold and notified the seller has accepted the bid. So
two sentences mean when it says congratulations on winning on your auction purchase?
We believe that's what it is, a congratulatory, you're the high bidder. I mean, that's what the record.
Different than being the high bidder, though, isn't it? I mean, it seems like unfortunate language.
Unfortunate language, and that was language that was out of their control, and that's what's in the record, is that the software method, this auction method, sends that part out, and they then do the part below that says where payments can be made, and then includes the upon acceptance of the seller 10% earnest money. So that's what they included, and the terms and conditions. And so yes, I agree. Unfortunate language, but that's how this auction method email goes out. So I think
runs out too. Can you talk about the dismissal of Gatsionis and the appellant's claim that that was improper because he was not participating and doesn't appear to be participating here either now?
This long, but we believe the Supreme Court, Celotex Court v. Catret, District Court possesses the power to enter summary judgment sua sponte as long as the losing party was on notice and had a chance to come forward. This was then also found the Iowa Court of Appeals 2007 in Bradley versus Manternach, where the District Court has the power to grant summary judgment sua sponte. And there, the claims based were on the same body of facts and law, and all parties had a chance to argue, and we believe that's clear here. All the claims that they've made in the petition are intertwined for Mr. Gatsionis and the DreamDirt defendants, and my clients there, they have an indemnity claim brought by Mr. Gatsionis as well, so they have the right to protect themselves, and the plaintiffs clearly had a chance to argue at summary judgment and present every evidence they had. So I'll give my time here, and if you have any other questions, I'm happy to answer. Thank you.
May it please the court, counsel. My name is Alex Barnett. I represent Vail Holdings in this lawsuit, who is an innocent purchaser of Track 3. The only claim against Vail Holdings in this lawsuit is a quiet title claim. Vail Holdings is entitled to summary judgment because plaintiff never obtained an equitable interest in Track 3 for all of the reasons that counsel just articulated. Vail Holdings is independently and also entitled to summary judgment because it is a bona fide purchaser of Track 3. There is no evidence in the summary judgment record that Vail Holdings or its sole owner, Dan Dolan, had any constructive knowledge of plaintiff's alleged equitable interest in Track 3. The only evidence is an assumption from plaintiff that Dan Dolan received a similar automated email when he successfully bidded on Track 2 in a tract of land that's adjacent to Track 3. From that assumption, plaintiff assumes even further that Dan Dolan would have then known that there was a higher bidder on Track 3 because he submitted bids on Track 3 but was not the highest bidder. There is nothing in the summary judgment record to support plaintiff's inference or speculation that Dan Dolan received an email in connection with Track 2. It's not in the summary judgment record. If it was important, he could have requested it in written discovery and included it. In fact, what's in the summary judgment record is Mr. Dolan's deposition transcript, which is attached to our reply brief at the district court level, docket entry 67. Mr. Dolan testified that he did not recall receiving an email in connection with his successful purchase of Track 2. Instead, he received a phone call shortly after the auction ended from a representative of DreamDirt who informed him that the seller had 4 hours to accept or reject his bid because it was a reserve auction and that was the bidding instructions. Mr. Dolan testified that surprised him. He was disappointed. He thought the highest bidder would win, but he received a phone call within 4 hours telling him that the seller had accepted his highest bid. There is no evidence that Dan Dolan would have constructive knowledge of plaintiff's equitable interest. The only thing that Mr. Dolan knew when he purchased Track 3 was that the seller of land in connection with this auction had the authority to accept or reject bids from the highest bidder. And that is exactly what is contained within the terms and conditions that Mr. Dolan agreed to, which are the same terms and conditions that plaintiff agreed to. The bona fide purchaser doctrine does not require perfect knowledge. Instead, it requires a prospective purchaser to conduct due diligence and charges that individual with the facts that, in quote, all probability would be discovered in connection with that investigation. That makes this appeal easy for Vail Holdings. The parties with capable counsel have fully briefed and argued this issue below before the district court, and the district court determined that plaintiff did not have an equitable interest in Tract 3. That is what a reasonable investigation would have revealed to Mr. Dolan or Vail Holdings in all probability. There are no public filings or any other record that would otherwise defeat the bona fide purchaser argument in this case. And for those
This way, counsel, but I just want to be sure I'm clear. You agree that if we were to conclude that there was no contract formed in the first instance, that would be all we would need to decide on your claim as well? We wouldn't have to go down the bona fide purchaser path?
Respectfully, I disagree with that, Your Honor. Pursuant to the case law that we've cited in our appellate brief, that's the first layer of defense that Van Holdings has in this case. But even if there's a question of fact as to whether there was contract formation, a reasonable investigation for Mr. Dolan would have led to the same conclusion that the district court reached, which was there was no equitable interest obtained by plaintiff in Tract 3, which therefore entitles Van Holdings to shield itself with the protection of the bona fide purchaser doctrine. Thank you.
Thank you. Counsel rebuttal when you're ready.
Thank you, Your Honor. I want to start with the issue of bona fide purchaser and inquiry notice. Now, the rule here is that when a buyer is aware of sort of unusual circumstances that would trigger a reasonable person to investigate, they are assumed to have all of the information that an investigation would have procured. So the unusual circumstances here are that Vail Holdings knew that there was an auction, it participated in the auction, it bid on this exact tract of land and did not win. So Vail Holdings knew that there was a high bidder out there, if not knowing that it was a purchaser. Now, as counsel just said, Dan Dolan's deposition is in the record. I think he may have misstated the docket entry. I thought it was 73 instead of 67. But I believe on page 16 of the deposition transcript, Mr. Dolan says that he really does not even understand what a reserve auction is, and that he thought that if you were the high bidder at an end of an auction, you are just automatically the winner. So he clearly knew that there was somebody out there who was the high bidder. He must have thought that person was the automatic winner. So did he do a reasonable investigation is the next step in this analysis. And simply put, Dan Dolan could have just asked DreamDirt, who is the high bidder? Is the high bidder making a claim adverse to reselling the property? Has the high bidder disclaimed any interest in this property? And if DreamDirt told the truth, they would have said everything that my client said to them. Minutes after the auction, or maybe perhaps hours, there were phone conversations between Stephen and DreamDirt. Stephen said, "We have a final contract. I intend to enforce it." If Dan Dolan had just asked DreamDirt, I think we have to assume that DreamDirt would have told the truth and would have said, yes, the high bidder is out there and he is saying that he has a final contract and that this is a done deal and that it is his property.
The words have to assume. Is there anything in the record that information was public? Who was the highest bidder, or was it confidential?
The bids were all based on numbers. I would say that since this is a summary judgment motion with my client as the non-movement, that all inferences of fact should be assumed in my client's favor, that we should assume that DreamDirt would have told the truth. I think that's a fair assumption. I think assuming that someone would have lied is speculative, and that assuming the truth is sort of the only natural or normal thing to say.
As you started off your argument at the beginning, I think the heart of the case is whether a contract was formed, and I understand your position is that a contract was formed. If we disagreed with that and said a contract was not formed, does that defeat your breach of contract claim, your slander of title claim, and your quiet title claim? Or do you agree those are the three that would fall away if there is no contract? And if not, how do they survive?
Your Your Honor, I have no argument to make. If there is no contract, I don't think I can survive on those counts.
How about the other three, the fraud claims? Do you think those carry on even without a contract formed?
Yes, I believe so, that those do continue on, because those are based on misrepresentations, and misrepresentations do not require, an actual contract. It's just.
Am I reading your briefing correctly that you're essentially relying on the same two misrepresentations for all three of those claims? The negligent, fraudulent representation and consumer fraud, that they're all, one kind of based on the nature of the auction and whether it was without reserved, and the other based on whether your client was told he won the auction. Are those two statements the basis for all three of the claims?
Essentially, yes, definitely for the negligent misrepresentation and the fraudulent misrepresentation. Consumer law is based on, I forget the phrase, but some sort of like abusive practices, something like that. So, and basically I would incorporate the argument that these types of misrepresentations, that the kind of abusive practices of making someone feel committed to a property to purchase it by calling them the purchaser and then sort of pulling the rug out from under them from someone, if I may continue. Yeah. From someone with DreamDirt who had superior knowledge and skill. I think those are abusive practices under the Consumer Fraud Act.
Thank you. With that, we will consider case 24-1163 fully submitted, and we will be in recess until 1 p.m.